Good evening. Thank you guys for coming out. I'm David Ramsey. I'm chair of the Department of Government here at UWF, and it falls to me to welcome you to Constitution Day 2022. Tonight's lecture is the third in a series of 3 lectures supported by the Jack Miller Center, and we're very grateful for their support. That funding was originally proposed to host events in 2020, and we're getting to complete them tonight on topics devoted to statesmanship, constitutionalism, and culture. These events never happen without a lot of assistance, so before I will forget. Let me thank some of the people that I can remember right now who have helped this event to come together. First and foremost, Michelle Hargraves, our new office administrator in the Department of Government, has done an excellent job of helping to coordinate all of the planning for this event. Professor Kennedy and his team from the Department of Communications, Jerry Brisky, here in the center, CFPA. Also, the support of the provost and the dean is appreciated for making these lectures a regular part of our life here at UWF. Of course, Constitution Day is not September 12th, it's actually the 17th. This is the day when the delegates who are present still in Philadelphia at the Constitutional Convention fixed their names to the draft of the Constitution that would be sent out first to Congress and then to the states for ratification. We've decided here, I guess this is now about our 15th year to run an event in honor of the Constitution. And we use these occasions to, not just to talk about the Constitution, but the questions that arise under it as we've grown as a country. And it's a very important part of these lectures that you, as members of the audience, remember that at the end of the lecture, you have a part to play as well. We bring in these speakers from around the country. We try to get a diverse group of experts who would represent viewpoints that are not represented in our curriculum, in our course offerings, that can add something to the intellectual life of the campus. And they do a fine job year in and year out of laying out an argument that's intended to provoke thought. But for this to really work well, you need to make use of the question and answer period. And so I encourage you, as you're listening to Professor Postell deliver his remarks, that you give some thought to what question you would have to ask, not just for your own benefit, but for the benefit of the whole group here. What you want to know, some thought that's coming to mind as you're listening to the remarks. And if you have paper or your cell phone, go ahead and write it out so that in case nerves come up, you've got the record right there. But remember, this event is a dialogue, a structured event, but there is space for you to contribute your questions, and I hope you'll do so. This year's speaker is Joseph Postell. He's Associate Professor of Politics at Hillsdale College. Before he was there, he taught at a school very much like UWF in Colorado Springs, University of Colorado at Colorado Springs. He's the author or editor of about five books of essays or manuscripts. The one that caught my attention and that is sort of the basis for his remarks tonight was Bureaucracy in America. Those of you who've had me before know that I am an admirer of Alexis de Tocqueville, and probably subliminally that sort of homage to Tocqueville's Democracy in America caught my attention. But he's also written just a number of reviews and essays, book chapters. Among the scholars of my generation of the Constitution, he's one of the talents, definitely, that's out there. So it's a great honor we get to have him with us tonight. Please do silence your cell phones, I suppose, for everyone's benefit, and join me in welcoming to the stage Professor Joseph Postell.
Good evening, everyone. It's a great pleasure and an honor to be here at the University of West Florida. As Professor Ramsey mentioned, the city of Pensacola and UWF remind me a lot of where I just came from 2 years ago. I moved in 2020 from the University of Colorado, Colorado Springs, which is a public university in Colorado with about 10 to 12,000 students, and it was a great pleasure to be there for 10 years. I had an opportunity to spend some time with students this afternoon, and they reminded me of my students at UCCS. They were kind, engaged, and it was a real pleasure to spend some time with them. It's a great honor to be here, and thank you for being here tonight. I'd also like to thank David Ramsey for the invitation to be here. I've been looking forward to this for a while. The topic that I'm going to be speaking about tonight is a question: is administrative law unconstitutional? My answer to that question will be yes. A lot of administrative law is unconstitutional, though not all of administrative law is unconstitutional. And my goal will be to provoke a conversation. As Professor Ramsey mentioned earlier, I hope to engage in a good dialogue with you about what I have to say tonight. And so I'm going to advance the thesis forcefully in order to provoke that response. I guess before proceeding, though, I should probably clarify what administrative law is, because most people are not really familiar with that term. Now, most people have not heard of administrative law, but almost everybody is familiar with what administrative law does. Over the past century, most of the power to make decisions in our national government has been transferred, has been moved from elected representatives who legislate to administrative officials. So just think about the COVID pandemic. It was administrative officials or executive officials who instituted eviction moratoria. That was the Center for Disease Control. Issued mask and vaccine mandates. The vaccine mandates in the workplace came from OSHA, the Occupational Safety and Health Administration. And executive officials at the state level imposed lockdowns, closed businesses, churches, and schools. These were not legislators that did this. These were executive officials or administrators. Now, my focus tonight is not about the merits of any of those policies. My focus is on how those policies have come to be enacted, and especially by whom they were enacted. The most significant thing to notice, and what I will be focusing on, is that these decisions over the past few years were made not by legislators, but by executives and administrators. The greatest political revolution that's happened in this country over the last century has been an administrative revolution. The people who make most of these policies in our political system today are bureaucrats. They make decisions and enact policies that the founders of our Constitution would have called legislative and judicial, as well as executive. The powers they exercise would have been considered by the framers legislative and judicial. And even in non-emergency conditions, just the ordinary circumstances of American life, they make the decisions. Air quality standards, workplace safety rules, fuel economy standards, and so on, the regulation of securities, of healthcare plans. These decisions are made by agencies. Name any policy that the national government is involved in, and there's almost certainly an administrative acronym that makes the calls. So administrative law is the name we give to two things. The first is the rules, the regulations, the orders, the guidance documents, the policy memos, and all the other legally binding decisions that come out of these administrative agencies. And the second thing we use administrative law to denote is the legal doctrines that govern when judges review the decisions made by these agencies. What I'll be talking about tonight is the first category. I mentioned all of these legally binding decisions made by administrative agencies. Is it constitutional for these agencies to issue rules and orders that have the force and the effect of law? Even a basic sketch of the fundamental principles of our Constitution raises serious questions. Most students in America today are taught what I would call the schoolhouse rock version of American government. In that version, the laws are made in the halls of Congress by people we elect. Then they're carried out in the executive branch. And then the cases arising out of these laws are tried by judges in independent courts. And we have this three-part separation of powers that works very neatly. And the reason our government is set up this way is to ensure a just and a fair system. And so 3 of the principles in this schoolhouse rock version of government are worth emphasizing. The first principle is the principle of republicanism. Our government is a republic, and that means it is a representative democracy. What this means is that the laws have to be made by people we elect. We choose through our votes. If we don't have this kind of a system, the laws might reflect the wishes of special interests or insiders who have special access to the halls of power, or just the will of the government itself rather than the will of the governed. The second principle is the principle of separation of powers. And this principle is based on the idea of human frailty and bias and the allure of power. Right? We separate powers to keep people safe from officials who will abuse power. If the police officer can both make the law and decide on whom to enforce the law, citizens are subject to the will of the officer, not the will of the law. James Madison wrote in the Federalist Papers in a famous sentence, the combination of all powers, legislative, executive, and judicial in the same hands is the very definition of tyranny. And the third principle that I want to focus on tonight is the principle of the rule of law. When citizens are prosecuted by the government, when their liberty and property are at stake, we make sure under our Constitution that they're afforded due process. And due process guarantees that the rule of law is followed rather than the biased decisions of adjudicators. So these 3 basic principles, representation, the separation of powers, and the rule of law, are all threatened by the most extreme aspects of administrative law today. That will be my contention. Okay, so let's take the first principle, the principle of representation. One of the crowning achievements of the United States Constitution is that it sets up a representative system of government. Through elections, we choose our representatives. We choose the people who make the law. That's what the Constitution's framers believed they were setting up. As the famous story goes, when he was asked by a citizen, "What form of government did the framers establish?" Benjamin Franklin replied, "A republic, if you can keep it." And a republic is a form of government, in the words of James Madison, in which the scheme of representation takes place. Representatives are people elected by the people to make laws on behalf of the people. The very first sentence of the Constitution, Article 1, Section 1, affirms the concept of representation when it declares, quote, "All legislative powers herein granted shall be vested in a Congress." All legislative powers herein granted shall be vested in Congress. That's what the Constitution mandates. Members of Congress are elected by the people, and they're the ones who hold the legislative power. The essence of that legislative power is the power to make laws. Laws are traditionally understood as rules and measures of action. So when these rules are violated, penalties such as fines and imprisonment follow. So Republican government is defined as a system when laws are made by representatives. Unfortunately, as Benjamin Franklin feared, we have not kept the republic. Laws are no longer made by Congress. Now, let me be clear. Congress passes statutes today, but these statutes are not laws. Rather, they're assignments of the power to make laws to other agencies. In short, Congress routinely delegates its lawmaking power to the administrative state, and this is where laws are actually made today. And if you don't like the rules they create, you cannot vote them out, and you probably don't even know who they are. This delegation of legislative power was most clearly on display in the debate over the Affordable Care Act. That's the law commonly known as Obamacare. Infamously, when Speaker of the House Nancy Pelosi was giving a speech in defense of the bill, she said to her audience, "We have to pass the bill so that you can find out what is in it." Now, most people totally misunderstood what Speaker Pelosi was saying. They thought that she was saying nobody had read the bill, or that she was saying they were going to vote to pass the bill before anybody read it. That was not what Speaker Pelosi was saying. She was making a more sophisticated point. She was saying that the real decisions were not contained in the Affordable Care Act. Rather, the real decisions would be made in the regulations enacted by the Department of Health and Human Services, and those regulations could only be promulgated after the bill was passed. So, for example, when the question arose about whether contraception and abortifacients were essential health benefits, as defined by the statute, nobody looked to the Affordable Care Act to answer that question. Instead, they turned to the HHS regulations. And this is the typical pattern of how these rules are made today. They're not contained in the statutes that Congress passes, but in the regulations established by the administrative agencies. Congress has given away its legislative powers to these bodies. Our laws are not made by our elected representatives anymore. They're made by people we don't elect who work in the bureaucracy. This has obviously diminished the importance of our elections, and in a real sense, it has left the people powerless. Now let's take the second principle I mentioned, the separation of powers. I've just explained that the legislative powers are held by administrative agencies and not by Congress. These agencies also have executive power, and in many cases they have judicial power as well. This is one of the hidden secrets of modern government today. Most people are completely unaware of the pervasive existence of administrative law judges and administrative judges. They're referred to as ALJs, administrative law judges. These are people who work within an administrative agency, work for an agency, and issue orders deciding individual cases involving the rules made by the agencies. When a person is accused by an administrative agency of violating rules made by an administrative agency, they are typically tried by people who work for the agency. These administrative judges issue fines and other penalties as part of their ongoing and regular responsibilities. Now, Article 3 of the Constitution, of course, grants the judicial power to the federal courts. And it declares that the judges in federal courts hold their offices during good behavior and that they receive a compensation which cannot be diminished during their continuance in office. In other words, judges are supposed to hold tenure for life or during good behavior, and their salaries are not supposed to be subjected to the will of other branches. The reason for creating this independent judiciary is pretty obvious. If the investigators and the prosecutors are in charge of hiring, reviewing, promoting, and compensating the judges, citizens do not really have a fair shake. Judges are, after all, human beings, just like the rest of us. Their decisions can be influenced by the people who have control over the perks of their jobs. If the judges' salaries are under the control of the agencies they work for, they will, of course, decide cases in favor of the agency. Perry Mason and Colombo were brilliant, although fictional, defense attorneys, but they never had to face administrative judges who were essentially on the payroll of the prosecutors. How could somebody defend themselves from such a tribunal? Now, to be fair, there are rules in place to protect administrative judges from their bosses. The agencies get to hire the judges, but the salaries are set by a different agency called the Office of Personnel Management. And the agency can influence the decisions about giving raises to the judges, but the Office of Personnel Management has the final decision. So there's some protection for these administrative judges. In addition, there are rules saying that the agency officials who do the investigating and who do the prosecuting can't supervise or direct the decisions of the judges. In other words, there has to be a separation between an agency prosecutor or an investigator and an administrative judge. But these protections are a poor substitute for Article 3 of the United States Constitution. It's really easy to circumvent them. Even if an agency investigator can't supervise an administrative judge, there are indirect ways to influence people who work down the hall from or on the floor above where you work. And experience has demonstrated this to be a real problem. None other than Representative Barney Frank, a liberal Democrat from Massachusetts, observed that, and I'm quoting him here, we have gotten allegations from administrative law judges of coercion, threatened transfers, and other kinds of pressures, end quote. The General Accounting Office, a nonpartisan agency of the federal government, reported that 6 different agencies had ALJs who complained that their bosses attempted to compromise their independence. One of these administrative law judges from the Department of Interior described his agency as a wholly vindictive and retaliatory environment. The evidence suggests that these administrative judges do not have the independence necessary to decide cases impartially. In short, the typical administrative agency today has not only executive power, but also legislative power and even judicial power. They make rules that are essentially laws, They prosecute offenses against their rules. They have their own judges to try cases arising from their prosecutions. Most of the cases tried today by the federal government are held outside of the judicial branch. One estimate from a famous administrative law scholar named Kenneth Culp Davis suggested that administrative trials decide 6 times more cases than the federal courts do. The results are entirely predictable. Federal agencies achieve remarkable win rates when they're in front of their own judges. The Wall Street Journal examined the win rate of the Securities and Exchange Commission in front of its own judges, and then compared it to cases won by the SEC in front of independent Article III judges. And the results were significant. The SEC won 90% of its cases in front of defendants when its own judges were trying the cases, and prevailed in 69% of the cases in federal court over the same period. So a pretty large discrepancy. Unsurprisingly, of course, the study also found that the SEC brought 4 out of 5 cases in front of its own judges rather than going to an independent court. So if you lose in front of the ALJs at the SEC, you get to appeal. Of course, you appeal to the SEC. And of the 56 cases appealed to the SEC during the same time that the Wall Street Journal was conducting the study, the commission confirmed its own ALJ's decisions 95% of the time. One SEC judge who was relatively lenient on defendants, named Lillian McEwen, was called into the agency's chief administrative judge's office, who questioned her loyalty to the agency for going easy on defendants, and notified her that the burden is on the accused to prove their own innocence. This is the chief administrative judge at the SEC. Sometimes we use the phrase judge, jury, and executioner to describe a situation in which power is consolidated in one person's hands. For most administrative agencies, that is child's play. Agencies are not judge, jury, and executioner. They are lawmaker, investigator, prosecutor, judge, jury, and executioner. Consider a typical agency today like the Federal Trade Commission. This is how the FTC typically operates. And this is an account from one law professor that I'm quoting here. The commission promulgates substantive rules of conduct. The commission then decides whether to authorize investigations into whether the commission's rules have been violated. If the commission authorizes an investigation, the investigation is conducted by the commission, which reports its findings to the commission. If the commission thinks that the commission's findings warrant an enforcement action, the commission issues a complaint. The commission's complaint that a commission rule has been violated is prosecuted by the commission and adjudicated by the commission. The commission adjudication can take place before the full commission or before a commission administrative law judge. If the commission chooses to adjudicate before an administrative law judge rather than before the commission can appeal to the commission. If the commission finds a violation, then and only then the affected party can appeal to an independent court. But the agency decision, even before the independent court, possesses a very strong presumption of correctness. Right? The commission does everything. And this kind of thing doesn't even raise eyebrows today in Washington, D.C. But if you take the Constitution seriously, it seems to protect us against precisely this kind of a government process. Okay, the example of the FTC raises 2 final problems. Both of these problems are challenges to our 3rd constitutional principle, the rule of law. One problem relates to where these agencies are located inside our constitutional system. Where do they fit? Most people reasonably would say that these agencies are part of the executive branch. And that is certainly true for many administrative agencies. OSHA, which is the Occupational Safety and Health Administration, is inside the Department of Labor. And the Secretary of Labor, of course, is accountable to the President. So this is an executive branch agency. The EPA, the Environmental Protection Agency, is headed by an administrator who is accountable to the President. But many of the most powerful administrative agencies today are called independent agencies or independent regulatory commissions. These agencies include agencies such as the Federal Trade Commission, the Federal Communications Commission, the Securities and Exchange Commission, and the National Labor Relations Board. Now, the primary difference between the executive agencies and the independent agencies is that the people who run or head the independent agencies are not directly accountable to the President. They're appointed for a set number of years, and the president may not fire them without cause before their terms are up. In other words, there are heads of independent agencies right now who were appointed by President Trump, even though he was voted out of office and he left almost 2 years ago. His appointees are still running many of these agencies. How did this happen? When Congress created these agencies a while ago, none other than Franklin Roosevelt, who's often thought of as a great defender of the bureaucracy, he challenged the constitutionality of creating independent agencies that the president could not hold accountable. He tried to fire one of Herbert Hoover's appointees to the Federal Trade Commission. This was a fellow named William Humphrey. Now, Humphrey, of course, was a Hoover appointee. He was not a fan of the New Deal, nor was he much of a fan of FDR, who crushed the guy who appointed him to office in the 1932 presidential election. So, Humphrey opposed FDR's policies, and he used his power on the FTC to subvert the New Deal, to obstruct it. FDR reasonably invited him to resign. Humphrey decided he'd rather not resign. He'd rather stick around. And FDR extended several more invitations to Humphrey to resign. And after Humphrey declined several of those invitations, FDR finally just fired him. The problem is that the statute creating the FTC specified that the president could not fire Humphrey without cause. So Humphrey sued for all of this back pay that he was owed because he was unlawfully fired. And when he died, his estate continued to press this legal challenge. That's what gave us the famous case in 1935 called Humphrey's Executor versus United States. And in that case, the Supreme Court of the United States ruled that it was constitutionally acceptable to insulate the heads of commissions from being fired by the president. In that decision, the Supreme Court declared that the FTC was not an executive agency, but was rather, quote, quasi-legislative and quasi-judicial. So the court endorses this notion of quasi-legislative and quasi-judicial agencies in 1935. And these quasi-legislative and quasi-judicial bodies have been around ever since. Now, FDR was incensed at this decision. He knew exactly what it meant. It meant that even though the president is held accountable by the public for managing the government, the president would not have the ability to control the people who were in charge of many of these decisions. And FDR called the independent agencies, this is quoting Roosevelt, a headless fourth branch of government not contemplated by the Constitution. So FDR called this a headless fourth branch that was at least in some tension with the Constitution. Today, independent agencies make many critical decisions for which the presidents do not take responsibility. So to take one example, the National Labor Relations Board in 2011 intervened in a case involving the Boeing company. Boeing obviously makes aircraft. They made a particular version of the 787 in Washington State. And after some deliberation, the Boeing company decided to create a new production facility in South Carolina. The reason that they did this was fairly obvious. South Carolina is known as a right-to-work state. This means that its laws do not compel workers to join unions, unlike Washington State, which is not a right-to-work state. And so Boeing planned to shift its production of the 787 aircraft from Washington State to South Carolina. Boeing built the South Carolina facility and hired 1,000 workers to work in the facility. And it was at that point that the NLRB commanded the Boeing company to close down its new facility and revert all of its production back to Washington State. It declared Boeing's decision to be an unfair labor practice prohibited by the NLRB. At a press conference, remember NLRB is an independent agency, the reporters asked President Obama about NLRB's decision, to which he responded, "That's an independent agency, so I can't get into the details of the case." The spokesperson for the NLRB said basically the same thing. This is a quote from the spokesperson, "We are an independent agency. It would be inappropriate for the White House to get involved." So the Supreme Court has endorsed the notion that Congress can create quasi-legislative, quasi-judicial agencies, combine the powers of government, and then put that power in a fourth branch of government. This has done damage to the principle of separation of powers, just as it has done harm to the principle of Republican government through representation. Okay. Am I painting a dreary enough picture? It gets worse. Don't worry, I'll try to end with something optimistic. But not yet. Citizens who are subject to this administrative process obviously have many impediments to getting a fair trial. But what happens when a citizen really decides to challenge the administrative state? When they really decide to contest a fine or a sentence that they deem unjust? Now, thankfully, it is possible, eventually, to get a trial in front of an independent judge in an Article III court, a judge who's actually independent of the prosecutors. However, this is where the good news comes to an end. In the first place, it is very expensive, very cumbersome, and time-consuming to reach this independent judge. Most initial decisions from agencies are final if they're not appealed, and most appeals are internal to the agency itself. For instance, appeals from decisions of the administrative law judges of the Environmental Protection Agency go to a body called the Environmental Appeals Board, which is, you guessed it, located inside the EPA. Commissions like the SEC and the NLRB hear appeals from their own administrative law judges as well. Unless there is a large amount of money or other severe penalties at stake, it just does not make sense to challenge and to appeal these decisions. It probably costs somewhere between $50,000 to $100,000 at a minimum to hire the counsel you need to drag out a legal fight with the administrative state, to get to that point where you reach an independent judge. And agencies, of course, can threaten to increase the penalties that they assess while the legal challenge is ongoing, either because of their prosecutorial discretion or simply because the fines rack up by the day. Even when a defendant is determined, however, to spend as many resources as necessary to get all the way to this independent judge, the deck is still stacked in favor of the agency. The agency's interpretations of the facts that led to the dispute and the law, the legal authority on which the agency is resting, those interpretations are given deference by the judges. One of these deference principles is known as the Chevron doctrine, and that doctrine means that if an agency's interpretation of its own law is not unreasonable, the courts have to uphold it. In other words, an agency's error has to be egregious, even for an independent judge to rule against the agency on appeal. The agencies therefore win cases in independent courts very frequently, almost as frequently as they win in front of their own judges. The NLRB decides several hundred cases in-house every year. About 65 cases on average annually go to an Article III court, and NLRB boasts on its website that it wins 80% of the cases that get appealed to an Article III judge. So in summary, modern administrative law is the result of an administrative process in which government agencies wield legislative, executive, and judicial power at the same time. Many of these agencies are independent even from the president. They make up a fourth branch of government, which has all of the powers of the original three branches. They make their own rules, they try their own cases, they get deference when they're taken to court. And this puts modern government in serious tension with even the most basic understanding of the principles of our Constitution. Okay, at this point, it's reasonable to ask, and probably many of you are asking, what's the alternative to this? I mean, Postell, do you really want members of Congress making decisions about air quality, drug regulation, broadband internet? These people can barely tie their shoes, much less understand the complexities of broadband internet. We want good government, even if it costs us representative government. And the issues we face today require experts, not members of Congress. So in the last few minutes of my remarks, I'd like to sketch out what I think is the alternative to this. But the most important thing I want to get across is that the alternative is not that government does nothing. One does not have to be an anarcho-libertarian to think that something is wrong with the modern administrative state. You don't have to believe that government has no legitimate power to make regulations, to think there's something wrong with the administrative state. There is more than one way to make and to enforce regulation. Regulation can be a good thing even if the administrative state is not the right way to do it. The best way to illustrate this is simply to look at American history. Most people think that before the administrative state existed, and if you're thinking of like when did the administrative state come into existence, 1900 is a good year to think about as like the beginning of it. Most people think that before that, it was like the Wild West. Anything went. You could use your God-given rights to liberty and property to do whatever you pleased, as long as you didn't directly harm anybody or kill them or steal their property. That's not how American government worked prior to 1900. That's a fiction. We call it the myth of laissez-faire. There was never a time in American history when the government embraced the doctrine of laissez-faire economics, the doctrine that says the government should leave things alone rather than intervene. During the late 1700s and the early 1800s, when the same people who wrote the Constitution and ratified it were setting up governments and carrying out the powers of government, the government's reach was vast during this period of time, the first decades of American history. I'll give you a few examples. The federal government, during this first few decades of American history, required all fur traders to be licensed and bonded, required all vessels engaged in the coastal trade and fishing to be licensed by the federal government. State governments were even more interventionist. Most states required inspections before goods such as lumber, beef, tobacco, salt, iron could be sold on the open market. You had to get inspections. You had to get a stamp of approval from the government before you could sell these goods, even in 1790. Occupations such as lawyers, doctors, tavern owners, auctioneers, innkeepers, my favorite, puppeteers, all had to be licensed by the state. No puppet shows without a license. I'm not sure why they thought that the puppeteers needed to be licensed, but they did, and the regulations were seen as legitimate. States during this period of time, say before the Civil War, set the interest rates that banks could charge for lending money. Transportation services such as ferries and carts were regulated by charters, authorizing them to exist in the first place, and the rates of carriage could be set by the government. And there are tons of cases from the first few decades of American history where these regulations were challenged as violations of liberty or property rights. And in almost every case, almost universally, these regulations were upheld by judges as reasonable restrictions of the right to liberty and the right to property. The key point I'm trying to make is that regulation itself is not a threat to the Constitution. It is the way in which we make the regulations and enforce them that presents the problem. I think it is possible to have regulations today without giving consolidated power to the federal bureaucracy. We can make workplace safety regulations, we can make drug regulations, we can make air quality standards, and we can enforce them. But we can do it with Congress writing the laws, with independent judges trying the cases, and with agencies doing the traditional executive task of investigation and prosecution. I was once asked when giving a talk on sort of a similar topic, okay, Professor Postell, how many federal agencies have to be abolished if you get your way? My answer is none of them. Not a single agency has to be abolished in order to follow the Constitution. Even if Congress writes the air quality standards into law and the judges try the cases, the EPA is still needed to investigate and to prosecute. But it would be a lot easier to hold our government accountable, and it would be a lot easier for citizens to get a fair day in court if we followed the Constitution's division of power this way. Now, it's true, and I readily admit, Congress does not seem capable of deliberating and legislating on any of the major questions we face today. Congress is a shell of itself, and we are deeply divided over issues across the whole political spectrum. Members of Congress don't seem too interested in talking to each other these days. They seem even less interested in compromising, and they're not particularly concerned about addressing any major issues, whether it's drug regulation, environmental protection, and the like. So given this sad state of our Congress, its ineptitude, can we really expect a functioning government where Congress makes the laws? My argument is that Congress's ineptitude is the result of the administrative state, not the cause of the administrative state. Congress's ineptitude is the logical outcome of Congress giving away its powers. Once Congress was allowed to grant its powers to the bureaucracy, its members became a lot more interested in performing rather than in governing, a lot more interested in fighting rather than compromising. Congress, in short, was corrupted by its delegation of power to the administrative state. It used to be a place where representatives worked together to make compromises for the common good. Congress was never perfect, of course, but it generally gave people the sense that government was listening to them, responding to their wishes, that their votes mattered. When agencies make all of the important decisions, who cares about Congress? Who cares about elections? What need is there for Congress to do its job? The problem with cutting our elected representatives in Congress out of this process is that government starts to look more like a foreign entity, not concerned about our interests, and therefore not worthy of the trust or the confidence of the people. The people start to think that government doesn't listen to them. And perhaps members of Congress would be more responsible if we required them to be more responsible, if we required them to govern once again. So on this Constitution Day, the framers of our Constitution, we should remember what they believed. They believed we were capable of self-government, that this was an experiment in whether self-government was sustainable. And they believed that a limited government, limited by a constitution with representation and the separation of powers, can vindicate this idea of government of the people, by the people, and for the people. If we want to keep that constitution, if we want to hand down the blessings of liberty to future generations, this is the problem we have to confront. How do we have a government that works without trampling on the Constitution's structure of power? And so we have to understand the challenge that the administrative state poses to the basic principles of our Constitution. All right, thank you for listening, and I look forward to your questions.
Okay, so the mic is open. Come on down and you can ask your question here.
Hey, how you doing? My question would be right there at the end, do we trust our government enough to retrieve the power that it's given away at this point, or do we feel that it's too late and they're too inept?
I still hold to the view that we can recover trust and faith in our government. Part of the problem with the distrust of government is that the people who have the loudest platforms right now actually may not be representative of the public. So there's a lot of research and data on echo chambers. You don't like somebody's political views, who's a friend on Facebook, you unfollow them, or you mute somebody on Twitter. And so it kind of creates a system in which the loudest voices might actually be the most extreme voices, which kind of perpetuates this cycle of conflict and polarization and distrust. And I don't really have a solution for some of those deeper problems. Some of them are technological. But I do get the sense that the first person or group of people in American politics who understand that we can restore faith and confidence in our political system by listening to the people, I think could actually do a great deal of good for restoring trust in government. I get the sense that people want their government to work well and still have hope that it can be brought around. Maybe that's just overly optimistic, but that's my hope, and I think that's my view generally. So all is not lost, even though it probably sounded like that for most of the talk.
So I'm still wrapping my head around a lot of things in my studies, and I was wondering, I actually originally thought the government worked as way as is described in the Constitution, but are we talking about what I'm minoring in is public administration is what we're talking about? Is that what we're
Yeah, well,
because that's my minor, and I'm like now realizing this is not what I thought it was.
I think public administration, that's a great question. Thanks for, I think public administration is broader than what I'm talking about here. So there are a whole bunch of agencies that don't do the kinds of things I'm talking about. Like I have former students who work in something like a parks department or purely, let's say, administrative jobs. They are faithful servants of the requirements of their job. They do it efficiently and effectively. And they're not lawmakers, they're not adjudicators. And a lot of public administration is that. People who genuinely want to help their communities, people who want to serve the public, people who are public servants, right? Part of the civil service. So most of what public administration is on a daily basis, I think, is that sort of thing, not dangerous in the sense that I'm talking about. The problem is that the heads of a lot of these agencies do make decisions that go way beyond what we've just described. They make the laws, they execute them. And so you can be a great public administrator without necessarily doing damage to the Constitution. And I think that's still a possibility.
Okay, so obviously something has to shift within the legislative body in order for these changes to start happening. Is this going to come from our elected officials who are already in the office, who are letting these systems happen currently? Or is this going to have to be a push from citizens, the voters, to put new people in the offices that will be in a position to change it?
Yeah. I don't think you can trust the people in Congress themselves to take the initiative to change things. So the way I think about how we create this shift that you're talking about is we try to teach people about how government really works, and then we try to equip them with the alternative so that they can vote in an informed way. Now, like the idea that people will vote to get rid of the administrative state or I mean, it's a very technical issue, and so it's hard to get voters to act on that issue. But I do think the more you teach people about this, the more it opens their eyes to where the decisions are really made, and hopefully would create a kind of political will to restore some of that to Congress. The one thing I will say about Congress doing this on its own is I think there are a lot of people in Congress today who wish that they had more authority than they do. They're kind of tired of what their jobs have become, which is the job of a member of Congress. This is an oversimplification, of course, but it is to give speeches, to raise money, and to show up and vote every once in a while on whatever the leadership tells you that you get to vote for that day. And legislators didn't come to Washington, D.C. just to be told how to vote every so often and then to try to raise money to fund campaigns. So I think they would love to have more power back. It's just that the constituents need to reward them for being legislators again. So maybe part of the solution lies with both members of Congress and their constituents.
Okay, I have like 3. The first one is, would you say that our votes don't matter anymore?
They matter for some questions that aren't fully yet decided by the administrative state, but for the most part, yes, I would say your votes don't matter.
And then, would you say that the government and or Congress doesn't want the people to know that they gave away their power? And if so, do you think it's necessarily fair that the people don't have a say?
The last question, is it fair? No, I think it's deeply unfair that in a representative system of government, the people's votes don't matter as much. Do members of Congress want people to know how the system really works? I think no. So there's an argument, I think it's a really interesting way to explain what's going on. Members of Congress like the idea that they can pass the responsibility for these laws onto the federal bureaucracy. So take like a typical law passed by Congress today that creates a major new program, the Affordable Care Act, right? Who votes against affordable health care? So amazingly, a lot of people actually did vote against the Affordable Care Act. But the vote was a kind of a signal that you wanted affordable health care, which of course voters tend to want that, right? All of the rules and regulations get passed over to some other place, and so you can blame the bureaucrats for the bad rules that have been made while taking credit for the affordable health care. And as soon as citizens figure out that members of Congress are the ones who created the problem in the first place, they could start to blame Congress instead of the bureaucracy. So I think some members of Congress like the system the way that it is. The re-election rates are well over 90% every cycle, and so, if you want to be a career politician, it's kind of a nice setup, right? The responsibility lies elsewhere, and you get all the credit. I think other members would just rather make the decisions because they came to Washington to make a difference, not just to get elected over and over again. So there are maybe two different kinds of Congress people who would react differently.
How would you suggest politicians are able to make these informed decisions? Because the people in charge of the agencies who are appointed are people who have been in the fields for years and years. So you use the EPA as an example a lot. How would you expect Congress to be able to make environmental regulations when people who work within the EPA are going up and they've studied environmental science and the repercussions of it for years?
Right.
And politicians, they usually study political science or other forms of government or interactions between people. It's two entirely different fields, and they're not, they may not be, it might not be a natural field for them to go into. So for them to make those decisions, not only would they have to be versed in those fields, but they would have to be versed in all of the fields that we make decisions about, because experts wouldn't be able to come and explain it to them, since they wouldn't be making an informed decision based on that. They would just be, because they wouldn't actually have the capacity to understand it, they would just be hearing back of what an expert's repeated to them.
Yeah, no, it's a great question, right? How do you expect members of Congress to know anything about environmental science when they're almost, they're all lawyers, right? Rather than people who've studied this. They don't have any expertise. So my argument isn't that they can't solicit the advice of experts, or that they have to just do this on their own blind. I would hope that members of Congress would hold congressional hearings at committees where they would bring in experts, including experts from EPA, to say, okay, we're thinking of setting the sulfur dioxide rule, air quality standard here. How many deaths on average will be caused through illnesses because of this standard? And the EPA can advise them, it'll cost us this much to institute these rules, and you'll save this many lives. And then they can make an informed decision, being accountable to their constituents about where to set those rules. So I'm not making an argument against bringing in experts to help advise members of Congress. But I do think ultimately members of Congress have to be held accountable for those decisions. So, expertise is not the problem. It's the lack of representativeness that's the issue.
Thank you for the lecture, first of all. I found it pretty helpful. In one of my legislative process classes, what we discussed was kind of the nature behind legislative politics and what messaging is and how the media plays a role. And the media likes to upplay the dysfunction within Congress. Mm-hmm. So what role does the media's focus on the dysfunction in Congress, do you think, play in the voters perhaps being ill-informed about the actions of the administrative state?
Yeah. The media likes dysfunction because we like to watch portrayals of dysfunction. It's my sense of it. Ratings are pretty high when you get to see people argue with each other. And so I do think this tends to distort the way we see politics. But the problem is it also kind of distorts the behavior of the people in Congress, and it makes them, they derive greater benefits from being dysfunctional as a result of that. So I certainly think the media plays a pretty significant role here, but we sort of reward the behavior, right? I think they're operating on a sort of model in which they want as many people watching as possible. And if we liked boring stories about people making compromises and getting along, maybe they would do more of that. But we tend not to like that sort of thing. We like the zingers in debates. We like people arguing with each other. And so that's what the media will give us. So in some ways, I think it comes back to us and what we reward and what we disincentivize.
Yes, so you mentioned the NLRB earlier with the ruling with Carolina and Washington.
Yeah.
I was wondering, do you think that that's not like a legitimate function of government, or like should we be able to, enforce, workers' rights, for instance? They had a contract in that plant. We shouldn't be able to take that away from them without due process. I mean, shouldn't we have a body at the federal level that's capable of doing that? And then I was wondering about with the EPA. Mm-hmm. Are you asking for the legislature to vote on each individual measure for each, like, say, particular particulate as they are developing and, carcinogenics, which could enter our water supply? Don't we need a very active administrative body capable of responding in real time to science, or do we need to wait for the legislature to come back in session so that, this legislature, which you repeatedly criticize for, completely gridlock, in a completely dysfunctional government, completely dysfunctional because of the amount of, we know what the issues are. And then I was wondering also, how is governance enhanced by, putting this, putting all of this, all of the individual decisions we're talking about with, like, the entirety of our federal administrative policy? How is putting that back into Congress? How would that improve governance when we, you're quite critical of the Congress. We know that, how are a bunch of, like, lawyers and maybe law professors or other people that we how are they going to provide better governance? I think someone mentioned earlier about, like, different fields and expertise. Like, I don't think we need, and I would love it if science teachers were, in Congress, but they're not.
Mm-hmm. So, just to be clear, I'm not against the NLRB having the power to enforce laws against, what the Boeing company did in that case. The concern I have is when the NLRB makes the law and then enforces it, right, and then adjudicates it. So if Congress votes in, say, a labor law to say, we are not going to allow production to be shifted domestically from so-called, non-right-to-work states to right-to-work states. If Congress makes that rule, then it's up to the NLRB to enforce it. And so my argument is not about the merits of the policies, and it's not about whether government has the power to do such things. My argument is that letting the same person make the law, right, execute it and adjudicate it is the concern. With regards to the EPA and the National Ambient Air Quality Standards, I'm sure that this probably could be disputed, and I'm open to, like, other different points of view. But I do think Congress could make those. So the Clean Air Act says you've got to make the National Ambient Air Quality Standards every 5 years. There are 6 criteria pollutants in the Clean Air Act. Lead is, essentially already been, regulated down to the lowest level under the Clean Air Act. So could members of Congress vote on 5 air quality standards every 5 years? I think that they could. And I think that would be a really nice place to start. So they'd have to obviously bring experts in, they'd have to get testimony on the various levels where they'd have to set the standards, but maybe the public would actually, like, be really interested in the debates that would be happening about this, and would follow the process by which the Congress would make these determinations. On carcinogens and things like that, I think you could create a statute that says, here's where we want the risk set, and that rule would be sufficiently precise and specific that you could then let the EPA carry out that sort of a law. So I'm not making an argument against expertise or against, like, a flexible government that's workable. I like workplace safety standards. I like clean air. I like clean water. I want the federal government to be involved in that. I do want my elected representatives to be making the policies, though. And so I think the Constitution at least requires that. If we're going to have a conversation about transferring the lawmaking power from Congress to these bodies, and we decide through constitutional amendment that that's what we're going to do, then that's the Constitution and we follow that. But we should at least be aware of the choice we're making and say, okay, we don't think Congress can do this anymore, let's let the experts make these calls. And then we should at least be open about the kind of government that creates instead of the the kind of government that we once used to make these decisions.
I was wondering, just as a nation, what is the best way to get our country to engage with us? Because I feel like, especially my generation, feels really nihilistic about voting, just because the more you learn, the more people that get a college education and you start to understand the electoral college, you just start to feel like it doesn't matter. Like, how would we go about interacting with our government?
Yeah, it's really tough in a very large country with so many people to make much of a difference. I mean, one argument for why your vote doesn't matter is because it's one of 300, several, over 100 million, right? And you're one of 350 million people in the country. I tend to think that more decisions are made locally and at the state level than we realize. I think people are actually sort of waking up to that. So as a practical matter, I actually think it's much more rewarding to dedicate your efforts at a place where you can, because of a smaller sphere, have more of an impact. With regards to the larger question about like having a government that really listens to the people, I think the challenge is on us. We have to be willing to study how things work and then think critically about what to do in light of that information. And so that's why education, I think, is so valuable, why a free society requires it, because if you don't think about those questions critically, you're not going to be able to really persuade others, get into conversations with others about these things. So one of the great things about this country is that we still have a pretty free educational system in which people are free to engage in these questions. I think this is a great illustration of that. And so anything you can do to contribute to that culture, to that, civility, right? Showing by example that you can have those conversations in a civil way, I think is, in your own way, you're contributing to like the health of your country. It might not feel like you're doing that much, but in a way you're doing more than a lot of other people who look like they have more power are actually doing. So, the framers of the Constitution were pretty clear that the government would reflect the character of the citizens to a great extent. And so our good character, we hope, would eventually make its way into the character of the government.
If a political party or ideology that aimed to gut the current bureaucracy took power in the federal government, would it be possible in our current institution, and what would it take to do so?
The answer is yes, a political party that wanted to, and I don't love the word gut the bureaucracy, because like I said, I actually don't want the EPA to go away, I don't want the NLRB to go away. But if it wanted to restore some sort of structural balance of power, yes, a party could do that. Notice I say a party and not a person. So this is a longer, and I'll tell you the short version of it, but basically the history of the presidency over the last 50 years, especially Nixon, Reagan, and Trump, was a history of presidents who tried to do exactly what you've described, right? They got elected in order to take on the government. It's this weird thing, right? You're going to elect me to lead the government, but I'm actually a sort of outsider who's going to come in and, take it on. I think 3 times it's been tried and it hasn't worked because it's just one person. And the president, for reasons I have explained, right? They're independent agencies that don't have to follow the will of the president. I don't think a president can do much. I mean, you have noticed, right, that like we've had presidential elections, presidents have come and gone, and it hasn't had like a huge impact on the daily activities of the government. So I don't think presidents can do it. I do think a party can, because a party could, through Congress, restore some sense of balance. And so people who think that this is a problem, my advice would be think more broadly than just the presidency. You elect a president to go in and fix everything. It should be much broader. And the Congress is much more reflective of the people as a whole rather than just like one political party or point of view. So I think it can be done, but I think it has to be done through a party and through Congress working collectively to try to bring a representative system of government back more into focus.
Good evening. So what do you believe would motivate our legislators to reel in the power of the administrative state? I mean, surely it wouldn't financially benefit members of Congress to fight against the status quo. So what would the proper conditions be for any effective changes to take place?
I think there are more members of Congress now who run as outsiders than ever before. I think a lot of them do run to like actually sort of topple the administrative state. I think the problem is they don't really know what they're talking about when they say the administrative state. That term is used all the time. Nobody has a clue what it means. That's why I tried at least to define it at the beginning. Like, the post office is not part of the administrative state. It's been around forever. It doesn't, you know, it does issue some rules actually about what you can and can't send in the mail, but that's not a legislative power. We have to be clear about what the problem is, and I think members of Congress don't really understand how modern government works. So maybe the best way to answer the question is to say, members of Congress need a little bit better education in how the process actually works. And that's not really what gets you elected these days. There's different characteristics that get you elected.
Hey there. Your main point seemed to be towards the idea that the work these agencies do isn't unconstitutional, just that the way the process works in regard to like the legislation and judicial qualities is. Yeah. But let's say that we suppose this was fixed so that they don't have both of those powers. Would you disagree with me that some of the functions or areas of regulation that these agencies focus on are still unconstitutional? Like the ATF per se, they do enforce some laws that are made by Congress, but they still do have the power to create their own regulations, which still could potentially be unconstitutional.
Yeah, I think that I would say that yes, if we fixed the legislative and judicial concentration of power problem, that those agencies would be constitutional. The question, of course, is whether there are other parts of, say, the Bill of Rights that an agency violates. So there are, of course, other parts of the Constitution that an agency could violate, even if it was just exercising executive power. But broadly speaking, you know, in response to the question, I would say if Congress made the law and the courts tried the cases and all the agencies did was enforce the law, then something like the ATF would be, yes, it would be, I think it would be constitutional. It's within Congress's enumerated powers, at least as the court interprets that today. And if the ATF is not actually issuing the regulations that are actually laws, then it's merely an executive agency. So interestingly, there was a recent case about this, of course, that the ATF issued rules banning bump stocks. This was after the Las Vegas massacre, and Trump was president at the time, and the ATF, you know, basically banned the bump stocks under a creative interpretation of a machine gun act of the 1960s, which banned a certain kind of firearm. And so, you know, if ATF were merely carrying out Congress's will when it did that, I don't think there would be any problem with that, in my view.
Good evening, Dr. Postell.
Hey.
My only question is just a piece of advice. How would you say what is the best way to actually engage with people that are disagreeing with you off the bat? Like, how is your process that you know people might not actually agree with what you're saying, but you still, even in your lecture today, had some type of optimism to actually hold for all of us? What would you say was the best way to actually go in knowing that they probably just don't even are gonna want to agree with you?
Yeah. Well, if I knew the perfect answer to that question, I'd have a lot more people agreeing with me, I suppose. But I think I try to. So I changed my mind on all of this stuff when I studied it. I used to be a kind of like, oh, you know, back in the good old days, you could do whatever you want before this big government showed up. And then I studied like actually how it worked in, you know, early American history, and they were like regulating more than we regulate today. And so I changed my views, and I've become much more favorable to like environmental protection rules and for regulation in general. And so I try to say, like, I like regulation. Regulation is absolutely necessary. You cannot, rights don't make any sense without regulation. Right? If I have my right to do whatever I want, then you don't have any rights, and vice versa. So you have to have regulation. And so I try to be very clear, like, I'm pro-regulation. I'm just pro-process. And we've broken down the process. Some people don't care much about process, and so maybe you just don't win those people over, but hopefully that at least helps establish some bona fides before I get going. And if you have other options I can employ, I'd be glad to talk to you afterwards about any of that.
Okay. Thank you, Professor.
Thanks.
Good evening. There's been a lot of discussion about like expertise and having that in congressional members, and you seem very in favor of them, like having, like being able to talk with other people who have those expertise. But my question for you is, with keeping in mind with commissions, do you suggest that they themselves have committees per each law that needs to be interpreted or created within Congress, or do you believe that Congress should set more clear statutes to then be given to a commission to enact?
Yeah. So I think Congress should use its committees to do the opposite of what the committees do today. They should use their committees for expertise. That was the original idea of having like a committee on agriculture, on armed services. And so I think the committees should help Congress devise the laws, and the hearings at the committee should be to inform members of Congress about the views of experts. And then Congress should vote on the laws, and then there should be also commissions in the executive branch to carry them out. So I believe in committees in the legislature, and I believe in executive agencies in the executive branch. But today, congressional committees are, they're not serious, right? Nobody asks a question, no member of Congress asks a question at a congressional committee because they care about what the person on the other side thinks. All questions are posed with a view to the cameras. And I think this shows members of Congress don't care about expertise anymore. But they don't vote on these things anymore, so why would they care about experts, right? So I do think members of Congress should use these committees that they have set up for expertise.
And then, if you don't mind, also,
Sure.
do you suggest that this reformation and this course of action be taken? You had mentioned that it started with, I believe the term was quasi-judicial and quasi-legislative.
Yeah.
And that was a Supreme Court decision. Do you think that the judicial branch could actually be the biggest course of action in reforming the way that this is set up, because they can go back and almost reverse that decision that they previously made?
Right. I am very skeptical that the courts will do this for us. I am also quite confident that members of the court want to do this for us. It's very clear if you read the decisions of the court over the past few years, they are very concerned about everything I just mentioned. By they, I don't mean the whole court. I mean a growing number of justices. The concern I have is that they think they can do this from the bench, and I don't think you can do this anyway except through Congress. So it's going to be quite contentious, I think, on the Supreme Court over the next several years as issues like the delegation of legislative power continue to come up. And even this case, Humphrey's Executor, that case that did the quasi-legislative, quasi-judicial language, there are members of the court who've not been very shy about saying they think that case was wrongly decided and that that's squarely in the crosshairs. But if you do this through the courts, there are a lot of problems that are going to arise out of that. So I'm hopeful that the people can do this through their representatives, not the court on high can tell us how to govern.
Thank you.
Yeah.
So that last question was exactly dovetailing into what I was going to ask you. You have already said tonight that you think the executive can't do it. Congress doesn't really want to do it. And you've now just said you don't think that the Supreme Court should do it, is what I heard.
Mm-hmm.
I'm sure you're familiar with, while everyone was talking about other Supreme Court decisions this summer, there was a decision with West Virginia versus the Environmental Protection Agency,
right,
where the court did try to provide some guidance, I think, as far as what kinds of questions may not be determined or answered by the agencies and must be determined by Congress. Do you think that's a good start? Do you think that there's a role for the judicial branch in conjunction with, hopefully, Congress, getting a jump start here as far as Congress changing how they delegate their jobs to people?
Yeah. I'm glad you brought up the West Virginia versus EPA case. That was a really controversial one. It was actually announced after Dobbs, which gave some indication that the court was actually thinking that was going to be just as controversial, or perhaps, I mean, it's not more so, but, close to as controversial. I think that case is a good example of the court saying, let Congress take the lead. So the question was whether the Clean Power Plan, basically having more solar and wind power in the state's energy generation, was something that the EPA could mandate through the Clean Air Act. And the Clean Air Act has not been really amended since 1990. Nobody was really thinking that much about the issue of climate change in 1990 when they amended the Clean Air Act. And what has happened, of course, is that the EPA, through the courts, have tried to basically shoehorn climate change policy through a law that wasn't really meant to do that. Teaching an old dog new tricks, this is teaching an old law new tricks. And so the problem with that, of course, is it doesn't really reflect the wishes of the representatives, it's just kind of drift that happens in the law. So I think the West Virginia versus EPA case was a good illustration of the court saying, we want the people's representatives to make this call. And we won't let the government move forward until the people have said, this is what we want government to do. I think it's okay for the court to have that kind of a role. Although you don't want the court to have to do that over and over again because it puts strain on the way we understand the courts. In particular, nobody understood what was going on in West Virginia versus EPA. All the headlines say, which is pretty much how these things are digested by public opinion, is court rules against climate change regulations. And I don't think that really gives you a sense of what was going on in the case, and it tends to distort the way we view the court. And the justices are very clear about this, right? They don't like the way that the media reports about their decisions because it's oversimplified and distorted. So I have hesitations about that, but that case in particular I think shows where the courts can help us.
Hi.
Hi.
I have a question on the efficiency with the alternative that you had. Yep. So when you talk about going back to the way that it used to be without the administrative state, we're thinking about the 1700s, the 1800s, right before the 1900s, right? And that was back when, America was a little bit smaller. Not everyone had the right to vote. Not everyone was able to participate in government. So it was a lot easier just to be more active and more engaged within politics. So I was wondering, do you think the way that government used to be is able to conform to modern day politics, or do you think that Congress is going to actually need to take reform? Because you said mentioning the committees and stuff like that, they do have testimony, they do have testimonies on the records, the experts do come in to that kind of is already happening. So my question is just, how are you going to conform the old way of government into modern day politics where you have 350 million people and they can't write all the bills, and the administrative state kind of helps government be more efficient and effective?
Yeah, okay, very good. So you certainly can't just copy what government did back then, right? That's not going to work because the circumstances have changed dramatically. So members of Congress represent 750,000 people on average. It's totally different than the way it used to be when you really felt like you knew your government, you knew your representative. On the other hand, I think we can at least adapt that way of operating to contemporary circumstances. And so the way I would want it to work is that members of Congress would sort of consult their constituents as best that they could before they voted on these things. And they would take testimony from experts, and they would maybe even convey that testimony back to their constituents. Communications these days are more about what the member wants to share with his constituents than what the constituents should know. And so I think if you can basically force this process back into the legislative branch, it gives the people more access, it gives the people more ability to follow what's going on. It is true Congress does all this today, but it's all a sham. Nobody really thinks hearings are there because a member of Congress doesn't have a settled opinion on a question. They've all made up their minds before they walk into the hearing, and the people who are there for a reason. They're deliberately chosen to advance the line that the member of Congress wants advanced. I testified once before a House committee on the judiciary, and one of the members, so everybody gets 5 minutes, every member gets 5 minutes to ask questions. One member showed up right before his 5 minutes, sat down, ranted for 5 minutes, ended it with, What do you think about that? Before we even got 2 sentences out, he was gone. The camera was on him for his speech, and then he left. That's not really a hearing in which like expertise is being brought to bear on a question. So in part, I think we should force our members of Congress to listen, and we should reward those people who do. That's another way, I think, of adapting the way things used to work to contemporary circumstances. But certainly you can't just copy the way it used to work. Our country's completely changed in really important and fundamental ways since then.
Yeah, just one more question. So I see that you put like a lot of emphasis on it's like being the citizen's job to like keep the congressional members accountable and things like that. But the like engagement right now is not really high. So how are you going to necessarily change that to increase the engagement and to increase like the communication between the constituents and their representatives?
It's a very, very good question without an easy answer. And I think the sad thing is the framers of the Constitution would have said, if you don't have an engaged citizenry, Republican government is probably not likely to exist for a very long period of time. So I suppose I would just implore citizens to not be passive and to try to be responsible and civil, but to be assertive in what they want their members of Congress to do and promote education and these sorts of things. I don't know if it'll be sufficient, but I'm hopeful that we can make things better if we follow that path.
Thank you.
Thanks.
Well, thank you for coming to Florida, free Florida, and I'm glad to know that our vote still matters here, for local elections especially. It is very important, and I do believe our national elections are just as important in a cohesive way. And you brought up some numbers. I'm a mathematician. So one thing about government I understand is Congress still has the power of the purse.
Right.
And if they would do a simplified budget and not give themselves an automatic 7.5% raise every year for every agency, perhaps we would have a bit more control over these agencies with this gross expansion, because if you did that over 10 years, that means the budget increases by 75%. On a different note, Congress, because they have that power of the purse, should take time to take a look at the bills they're actually passing and the cost effectiveness of that, and have some breathability between review of legislation before it's enacted, and perhaps separate these bills out into the categories that the monies and the laws are going to be dictated to. So if a bill says Clean Air Act, it should be purely Clean Air Act. And that would be a good guiding force, because then the American public would know more about what's actually being voted on than a 2,700-page bill that nobody has had the luxury of time to read before it's jammed through.
Yeah, so one of the things I think that's important to note here is that members of Congress used to use the power of the purse really aggressively to impose accountability on agencies. So if you were on like an appropriations committee, the agency that was subject to your appropriation, you could use a line item in the appropriation to control how the agency used the money. And this, of course, was back when Congress used to pass appropriations bills. Today, as most of you know, Congress has a sort of deadline to pass, an ongoing appropriation because the debt limit will get hit and the government will shut down. So usually like 2 days before a government shutdown, they just cram everything into an omnibus bill called a continuing resolution, pass it, and then go home. That, I think, has dramatically weakened Congress's ability to oversee the administrative state, because money is one of the ways that it used to do that. And so the decline of Congress's ability to control its own spending, I think, has been a significant reason why the Congress is no longer working as effectively as it once did. So I think that's an important part of the overall story that you rightfully highlight.
One other point, are you keenly aware of how they actually vote these days with electronic cards?
Yeah.
It was pointed out to us recently that many of the junior representatives offer their cards to the head senior members of Congress to allow them to vote effectively.
Well, it is sort of a thing that people will go into the House and look at the board and see where their colleagues are voting, and they'll tend to vote with their colleagues.
Yeah, I'm concerned that there's not more accountability for the individual.
Yeah, good, thanks.
So I think we can all agree that nothing is going to change overnight. And so one of the things you brought up very early on was the fact that a lot of the issues are with these independent agencies that do not report directly to the president.
Right.
So would one of the first steps, or what would one of the first steps be? Would it be like, let's bring those back underneath? So kind of almost reversing that 1935 decision that said that that was okay for them to have independent agencies, and bring it back underneath the executive branch, which would then put that power at least somewhere, and accountability for that power somewhere, and then gradually, because at that point in time, if there's a difference in party between the president and Congress, then they're much more likely to try to pull some of that legislative power back.
Yeah, it's a great question. So like, which side of the dilemma do you take? An all-powerful executive who has all of the executive and legislative and judicial power in one set of hands, and every 4 years you have the most important election of your lifetime to decide with this one election the future of the entire country? Or do you set up all these independent administrative bodies that really answer to nobody? I mean, obviously this is the less ideal situation, right? So, but I do think if you value accountability, you would at least get more of it by going with that first, right? That eliminate the distinction between these independent agencies and these executive agencies. And I'm not sure, I've thought about both sides of that question. I'm not really sure where I stand, but I'm probably sort of leaning in agreement with you that that would be a good place to start. And we might be there relatively soon because, as I mentioned, the court is going to look at that 1935 decision again in the near future.
We have time for one more question, if anybody. Okay, well, I'm going to go ahead and say you guys have acquitted yourselves very well. That was a lot of questions, and I think you stood up, you didn't cower with the questions, so I think it's a success. Please join me in thanking Professor Postell.
Thank you all.
He has graciously agreed to stay a little bit longer. If you are anxious about speaking into a microphone, we'll turn the mics off, and you can come ask him your question face to face without other people having to hear. Otherwise, thank you for coming out, and have a safe drive home.